All right, we're back with Due Process for Dads. This week we'll be discussing paternity with Attorney Blair Johnson. I have with me here, just before we start, I want to introduce our new staff member at the Killer Center. His name is Isaiah Fisher. Isaiah, you want to tell everybody a little bit about yourself?
So my name is Isaiah Fisher, 25 years old. I'm a husband, a father of 2 kids. I'm also a music artist. I've been making music all my life. I actually got a show this weekend in town, so that's pretty exciting. I'm excited to be a part of this journey, be on this journey, be a part of this Killer Center here with James. And I'm excited, man. Yeah.
All right. Yeah. So, Blair, how you feeling? You ready?
I'm ready, man. Let's do it.
All right, sounds good. So I'll add our presentation to the stage and go for it.
All right, let me expand my screen. All right, evening, everybody. Welcome aboard, Isaiah. It's good to meet you, and it's good to be back talking tonight about paternity. So before we get started here, I want to talk about some acronyms, as always. So what exactly is paternity? Paternity is the legal parentage of a father for a child. We don't really talk about maternity, which would be motherhood, legal maternity of a child by a mother. The issue under the law is traditionally been establishing the father for a child after the mother's given birth. A couple of acronyms here. So ROPA, we're going to be talking quite a bit about ROPA, and that's short for the Revocation of Parentage Act, and that falls under having to revoke paternity if it's already been established through a couple of different channels. AOP is an affidavit or an acknowledgement of parentage, which is a sworn statement signed by the biological mother and the second parent. Typically, it's a father, acknowledging that second parent is the biological and legal parent of that child. It's typically done. It's done when parties are not married, and it usually happens shortly after the child is born at the hospital. A couple of other terms that come up in paternity are presumed father, and that's a father who's presumed by law to be the father of a child by virtue of being married to the mother at the time of conception or birth. So there's a presumption of paternity in that situation. There's also an acknowledged father, and that's a father who has been acknowledged by virtue of signing an affidavit of parentage with the biological mother. And there's an alleged, or what's called a putative father, and that's a father who is alleging to the court in a pleading that he believes he's the father of a child. And as we've talked about before, there's also standing, and standing is something that is a big deal in these cases because you're going to fall under one of these headings. And standing generally is just the right of a party to bring a lawsuit because they are interested. There's a little bit of, I can still hear you guys, just so you know. James. There we go. All right. The right to bring a lawsuit is an interested party in a future court action, such as in this case, being a biological or legal parent of a child. All right. So who has standing to file a case for paternity? The biological mother does. The presumed father, that would be the husband in a case, and it's typically done if they don't want to be the father because they believe this child was conceived with another man. The acknowledged father, and that's a father who signed the affidavit of parentage, and an alleged father, a father who believes through different scenarios, usually it's around the timing of conception, that he was engaged in sexual relations with a woman, and therefore he believes and is alleging that he is the father of this child. Then there's the genetic father. So it's a father who's been determined by DNA testing to be the father of a child. The Department of Health and Human Services, DHHS, has standing to file a paternity case, primarily because they have an interest in ensuring that a child who's brought into this world um, and is receiving state assistance, that there is a father out there that they could ask the court to charge child support for. So because, and this only comes up when a child is receiving some form of state benefits like Medicaid, SNAP, TANF, that sort of thing, they would intervene then and file an action to establish paternity so they can get child support charging to the mother so the state of Michigan can be reimbursed some portion of the money they're paying for that state assistance. And then finally, a Michigan court itself actually has standing to file a paternity action if there is a child support case started in another state where a father is paying child support, but that state didn't make a determination for paternity, and that child is now presently living in Michigan. So we've talked about this before, I know, but like Indiana, for example, they don't require custody and parenting time to be established to order child support. In Michigan, it's a bundle. So there are other states out there too where they can order child support without there being a formal determination in that state of paternity. But if the child is living here in Michigan, and in order for that parent to now seek some kind of paternity here, a Michigan court could actually initiate a paternity action on behalf of that father or on behalf of the child. So all that is to say, there's a lot of different people who could bring an action for paternity, which is different than a lot of the other cases we've talked about so far, which custody and parenting time, you're talking about basically two parents. There's a whole list here of individuals or agencies who could initiate an action. So how do we, so we're going to talk about two different scenarios here generally. We're going to be talking about establishing paternity, getting paternity established, what happens and how you get that done. And then in the second half, we're going to be talking about how to revoke paternity. If paternity has already been established in some fashion, how do we undo that? So establishing paternity, we first talk about jurisdiction. Where do I bring an action? So you got to bring the action in the county where the child resides. You would file either a complaint or a motion, and we're looking at two scenarios under this category for establishing. When a child is born or conceived during a marriage, that child is presumed to be the product of the marriage. Therefore, the husband in that or second parent in that marriage has legal paternity. And so an interested party would need to file a ROPA action. That's that revocation of paternity statute we talked about, in order to revoke or rebut the presumption that that presumed father is not in fact the biological father of the child. If there is a divorce case pending, you would file a motion in that case. If there's no divorce case pending, then you would file a complaint, which is a separate action to revoke paternity. When a child is born or conceived outside of a marriage and an affidavit of parentage, that sworn statement has been signed, and both parents don't contest paternity, in other words, they say that this is paternity, then paternity has been acknowledged and formally established, and now you just proceed with filing a case for custody, parenting time, and child support. And that's that case code at the bottom here. When we talked about custody a couple of months ago, that case code would be a DC for domestic case custody type. If an affidavit of parentage has been signed and either the parent or a third party want to contest that paternity, then you would have to proceed with filing an action to revoke paternity that we're going to talk about later. If an affidavit of parentage has not been signed, in other words, there is no acknowledgement by the two parties that the father is the father of the child, then a party must proceed to file to establish a paternity case, and that's a complaint to establish paternity. And the case code for that is DP for domestic paternity. And another side note is that if paternity has been established in another state, then through what's known as full faith and credit, Michigan would recognize that paternity establishment as valid in Michigan. So those are the two avenues. How do you go about formally establishing paternity? So you start a new case by filing a complaint, getting a summons, and this is very similar to what we talked about with custody, parenting time, and child support the last couple of months. You got to complete a form. Anytime there's a case that's going to potentially involve custody, you have to fill out this affidavit that there are no other parties or any other states or agencies out there who may be in some way connected with this child in a custodial fashion. You got to serve the other party with that. And again, this can be done by either mom or dad, so that you'd serve the other party, whether it's mom or dad, with that complaint. And then that opposing party has 3 weeks or 4 weeks to file a response. And again, like the warning we talked about earlier, a couple of months ago, is that if you don't respond, it may result in the court making determinations in or against your interest without your input. So absolutely, anytime you get served with a complaint and a summons, do something. Even if it's going to the self-help legal center in Berrien County or getting online or calling an attorney, don't ignore it, because once you've been served, you're under the jurisdiction of the court, and decisions can be made that'll affect your rights without your input. Once a party has filed a response, the court's eventually going to issue a scheduling order, make referral to mediation. And this is very similar to the custody and divorce track that we talked about. The main difference, though, is, as I've underlined here, is that before proceeding to any issues on custody, parenting time, and child support, the court has to conduct genetic testing and find that there's a good and a valid reason to order such testing to determine whether, in fact, there is a DNA relationship between the alleged father and the child. And then the rest of the stuff would just continue on like we talked about a few months back. At the conclusion of that process, either by trial or by agreement, the court's going to enter an order that defines the rights and obligations of the parties with respect to that child. And as again, in Michigan, it's a bundle. So if paternity is established, then Michigan law requires that a court make provisions about legal custody, about a parenting time schedule and parenting time rights, and the award and order of child support. So when you file for paternity and you establish paternity, the next outcome in that case, like a DP case, is going to be an order for custody, parenting time, and child support. So it's not like you have to do one and then do the other when you're filing to establish paternity in Michigan. So let's pause and talk about genetic testing. So what is it? How does it work? So, going back to the distinction between a child born during a marriage or conceived during a marriage and that presumption, we're talking about outside of marriage. So parties can sign an affidavit of parentage acknowledging that the father is the biological father of the child, and that establishes paternity. And that it operates essentially as a consent. And that can be done without testing having ever been ordered. And in fact, that's one of the, it's a one-page document. That's one of the warnings on that form that we'll talk about it here on the slide. So when you sign the acknowledgement of parentage, your mom and presumptive dad are saying, or alleged dad, I'm the father. This is the father, even though we're not married, and there isn't a marital bond that would presume that child to be the father's. We believe that he's the dad, and so we're going to sign this form. Um, Otherwise, without that, the only way paternity can be established legally is through genetic testing. And that can either be done voluntarily, and that's through out of court testing that the parties can do on their own. It can be an over the counter test that you do, at Walgreens or CVS. Those generally run $30 to $40. That would then indicate that either rule out or prove the biological paternity of the child. But then for it to be enforceable, the parties would then have to consent in a court order or then proceed to sign that affidavit of parentage. Because that over-the-counter test is not necessarily an accredited test. Paying $30-40 for something that you can do at home is not necessarily as viable and reliable as the second option here, which is if you have to go to court and both parties don't agree, that this over-the-counter test is valid, then the court would order testing through an accredited testing facility. There's like 4 of them right now in Michigan, and that cost is obviously higher. So it runs about $300 to $400. But it's at a much higher level, more authenticated, valid outcome that then, if it's again proven, would result in the court issuing an order of paternity, and what we call it in Michigan is an order of filiation, filial for family. So genetic testing, just by what it is that it's DNA testing that verifies the presence of genetic markers between the father and the child. It's typically done with a cheek swab, and it's done through mom, child, and the alleged father or suspected father. The results get sent in, the samples get sent into the facility, and then the report that you get back will have a lot of different names and numbers of different chemicals and things like that. But at the very bottom, it'll say what the percentage is of likelihood that this man is the biological father. And the standard for it to be valid in Michigan is that the results must show that this person is greater than 99% likely to be the biological father of this child. Anything less than that would result in the father being excluded by DNA testing. Those results through that accredited agency are actually filed with the court. Copies are provided to both mom and alleged father so that everybody sees what that report says. And obviously, if the alleged father is excluded by the DNA testing, then that action to establish paternity is dismissed because the testing ruled out that person as the father. If an alleged father is included by virtue of having greater than 99% in common with these genetic markers with the child, then the court then would proceed to the custody portion of the action to make findings on custody, parenting time, and child support. And all of those provisions that we talked about a couple of months ago would then apply in terms of the 12 factors for custody, the 7 additional factors for parenting time, the Michigan child support formula for child support. So, paternity case is a little more complex than your standard custody case because you've got to determine whether or not this father is the biological father before then proceeding on with the custody portion of the action. So what does the law say about how you establish paternity? The burden of proof is on the plaintiff or the moving party to show by a preponderance of the evidence that the alleged father is in fact the father of this child. And preponderance of the evidence is slightly more than 50%. So it's a pretty low burden of proof that you have to demonstrate. And what we're doing here is we're getting to the position where the court would then order the DNA testing that's going to be the definitive the determinant, because that DNA testing is going to decide whether or not, in fact, this person is the father, right? What we're talking about here, the burden of proof, is getting to that point where the court would actually order the testing. So that's a bit of an invasive procedure. And so a moving party in a case has to show there's a really good reason, and not just some strange person off the street saying, I think I'm the dad, and therefore just let me in and make that person go do a DNA test. Because there is no paternity established yet, the burden of proof is actually lower than revoking paternity, which is what we're going to talk about later on. That's a higher burden of proof. But what you have to show then, in order to get to that order for DNA testing, is you got to establish the time and place as near as possible that the mother became pregnant with the child. So date of birth minus about 39 weeks, that gives you around the time of conception. And then we look at what was going on with the parties at that period of time. We also have to determine that the child was actually born, right? So we have a child who's then born on a certain date, and that mom was not married at the time the child was born, that the alleged father is the biological father of the child, and we have to rule out the possibility there's other men. So what we're looking at, essentially, the evidence that's typically needed is what was happening in mom's life, really in a sexual nature, around 39 weeks before this child was born. And testimony from the mother, from the alleged father, those are the two primary sources of evidence that the court's going to hear. In other words, I hate to be crass, but who was mom sleeping with 39 weeks or so before this child was born? And was it a one-off situation with this person? Were they in an ongoing relationship over several weeks, months, or years? More and more people don't get married these days than say 25, 50 years ago. So a lot more children are born out of wedlock, but you're still looking at what was happening around that time of conception. What other men could potentially be the father, or is this the only person that was in a sexual relationship with the mother at or around the time of conception? Sometimes you can have documented evidence like, social media posts, text messages, things like that, to sort of substantiate that there was a connection, at least romantically, between this alleged father and the mother around the time of conception. Family and friends testifying, that these two were in a sexual relationship. And again, all of this is to get to that point where the court would then actually order the DNA testing. Once you get those results, you might, it's rare, but you might need to have an expert in the field of genetic testing substantiate those results. But usually there isn't under the law. You don't have to lay a foundation, is what it's called. Once the court has ordered that test to be done, the test results are admissible without any other evidence. So there isn't a foundation that needs to be laid by a party to have those admitted into the court record. I've never experienced this, but it certainly has come up in other cases where, the physical resemblance between the child and this alleged father can be prima facie evidence of paternity, right? And in some cases, I don't know of any in Berrien, but maybe in other counties, the child can actually come into the courtroom and be observed by the judge. If it is, clearly that obvious that there are physical resemblances between this alleged father and the child. So that's the type of evidence that's typically needed. But again, That's to get you to the point where the court says we have seen enough. Now we are comfortable making mom, child, and alleged father do a DNA test, right? So that's the idea of getting to that DNA test order. So that's establishing paternity. And again, once you've established paternity, then custody, parenting time, and child support naturally unfolds. If the DNA test results exclude the alleged father as the father, then the case is dismissed and you're done. So, pivoting now to revoking paternity. When paternity has been legally established in some fashion, how do we undo that? So the jurisdiction in this situation is a little more broad, and jurisdiction is, the state, really, the state of Michigan. Venue is the county. So which venue, which county should we be hearing this case in? Which circuit court? The case must be filed in the county where either the child or the mother resides, or if neither mom or child lives in Michigan, then you could actually bring the case in the that says country, it means county, in the county where the child was born. So let's say if mom and child live in Missouri, right, but the child was born in Benton Harbor, Michigan, then an interested party could file an action in Benton Harbor, Michigan, in Berrien County, even though mother and child are not living here. So it's broader than establishing paternity. There's more scenarios to consider with revoking paternity, so we're going to walk through these. So one scenario, and this is where we get into these terms that we started at the beginning of the session with. When a child is born or conceived during a marriage, then the child is presumed by law to be a product of the marriage. So an interested party, and that could be mom, it could be presumed dad, it could be alleged dad, it could be the Department of Health and Human Services, right? All of those interested parties that we talked about on that second slide could bring that action to file a motion or a complaint to revoke paternity under the Revocation of Paternity Act, or ROPA, to revoke or rebut the presumption that presumed father by virtue of marriage is not in fact the biological father of the child. So you can do this if, one scenario where this often comes up is husband and wife have filed for divorce, and maybe they've even been separated for a while. And then finally somebody files for divorce, but either, at the time of filing or during the course of the divorce, or even before the time of filing, mom has a child who the husband does not believe is his child. And so, that husband could actually file to say, even though I'm married to her, we were not in a sexual relationship at the time this child was conceived, and therefore I don't want to be the father of this child. This is not my child. And so, a husband could file that in a divorce case. The wife could, or that other person who believes he's the father could actually intervene as a third party in that divorce case and file. And the idea is really, if there's already a case pending that in some fashion is going to address custody and custody rights for a child, the court would rather we do the ROPA case in that existing action rather than starting another case, right? Because then we potentially have two different things dealing with a similar subject matter happening in two different courtrooms, two different timelines, and it's wasteful and it can be confusing. And so if there is something that's already pending, and even if the divorce, frankly, has been finalized, it can be reopened, and a party can come in and actually file a motion, a ROPA motion, in that closed divorce case after the divorce is finalized to revoke paternity. So that's scenario one, presumed parent during a marriage. Scenario two is when a child is born or conceived outside of marriage, and two people have, the mother and another person, father, have signed that affidavit of parentage. So in that situation, you have an acknowledgement that that there is a father, and it's not necessarily a testing has been done or anything like that, but the two, mom and acknowledged father, signed a legal document saying, we're not married, but this man is the father of this child. So in that situation, you have an acknowledged father. Therefore, an interested party would need to file a ROPA action to revoke that affidavit of parentage. Um, you would do that typically by filing a new case because there isn't already a case that's been opened for this child. So you would file a complaint to revoke paternity in that situation. The third scenario is when there's a court order. So there's already been an order establishing paternity or an order of filiation, so that paternity has been legally ordered, in which case an interested party would need to file a motion in that existing DP paternity case to reverse the order. And sometimes it's rare, but sometimes these paternity orders can be issued without DNA testing by virtue of, let's say, two parties consenting and saying, we don't need to waste the court's time and trouble. We don't need to have the DNA testing. We're just going to consent to this court order for paternity. And so that would be the third scenario, would be basically filing a motion to revoke or reverse a court order. So we got presumption by law under marriage, you have acknowledgement by law under an affidavit of parentage, and you have ordered paternity by virtue of a court order. So what matters in these cases, and it's not the case with establishing paternity, but what matters in revoking paternity is timing. All right. And as I've noted at the bottom of this thing, is that, and this is Michigan law. So the court is balancing the interest, but what it is that the Michigan legislature has said we need to balance the interests in this situation between the possibility of an established relationship between an acknowledged or a presumed father and the child versus the rights of an alleged or potential father to have a relationship with this child. So again, we're dealing with a scenario where there's already been some form of determination that there is a father for this child. And what we're looking to do is change that, to undo it. And so there's a balancing act here with these time periods that we're going to look at between undoing, and basically wiping out an established relationship between parent and child versus the right of this other parent over here to establish and have a relationship with this child going forward. To set aside a presumption of paternity in a marriage, an interested party has to file a complaint or a motion within 3 years after the child's date of birth. However, a presumed parent, that would be the husband in a divorce case, can file a ROPA action at any time during that divorce case. So while revoking paternity presumption of marriage for anybody else, you can only do it up until this child turns the age of 3. If the presumed parent, who's the husband in a marriage, says, this is not my child, it doesn't matter whether this child is 10 or 12 or 15, they could ask the court in their divorce case to revoke that presumption. Now, doesn't mean the court's going to do it. We're going to talk about that a little later on, but they have a right to bring that. To reverse an order of filiation or to revoke an affidavit of parentage, a party has to file a complaint or a motion within the later of either 3 years after the child's date of birth or 1 year after the date that the order of filiation was entered or the affidavit of parentage was signed. So it's the later of those two things. And that's where we're getting into this balancing interest is, for children who are older than 3, there may have been an established relationship that we're starting to look at undoing, which is a big deal. As well as then, the period of if determination of paternity, either by signing an affidavit or the court issuing an order, only happened less than a year ago, and the child is older than 3, you still could bring an action at that point in time. So it's the later of those two different events. There is an exception that the court has the authority to extend the filing deadline period under any of these scenarios: marriage, court order, or affidavit of parentage acknowledgement. If the moving party did not file an action within that period of time due to mistake of fact, so there was some mistake that one party or all the parties had about what they believed. Some could be as simple as misreading the DNA test, or the DNA test that we took over the counter actually got the names mixed up. That's a mistake of fact. Probably the most common in my practice is newly discovered evidence that by due diligence, meaning, really trying, could not have been found earlier. A lot of this comes up, frankly, in this day and age with social media, that people will say things and post things on social media, or sometimes it's even a potential father seeing the child's pictures on social media and say, hey, that child looks like me. And I know that back in the day, mom and I were in a relationship. Maybe this could be my child, but if you didn't know about it any other way and you just found that out, then that would be newly discovered evidence. Fraud, that there was some collusion where the parties, typically the 2 people signing the affidavit, knew in fact that the acknowledged father was not the biological father, but chose to sign the affidavit anyways, then that's fraud. They've committed fraud. Misrepresentation or misconduct, that's rarely ever seen. Duress is, if somebody was, pressured into doing something or not doing something. And so I will say that it's hard, that these standards are very hard to meet. I have been successful in my practice in meeting them. And again, what we're talking about here, right, is the authority of the court to order parties to take a DNA test, right? And so we don't even want to open the door in a situation like this if a child is, say, 5, 6, or 7 and has already established a relationship with the presumed father, with the acknowledged father. The other parent has had enough time under the law to come in and do something about it and has chosen not to. The law says we're going to shut the door. Unless we have a really, really good reason, we're going to shut the door on your ability to intervene and change that, because that would have a significant upset in this child's life. And that interest in maintaining continuity and stability for the child overrides the interest of the party who is seeking to either undo the paternity or actually, step in and be the father in place of another person who's been serving as the father. So let's talk about the affidavit of parentage. The AOP only applies in situations where children are born out of wedlock. If 2 people are married, you don't do an affidavit of parentage. Most often, the AOP is signed at the hospital shortly after the child is born. A social worker will come in to the mother's room. It's usually the day after birth, but not necessarily, to explain the process, explain everything that's happening, which raises some proof problems. If the mother had to, undergo some anesthesia during the delivery, right, and may not be entirely coherent. Maybe it was an extended labor, and they're just exhausted, it's a real sketchy situation. But that's the primary way that this affidavit of parentage comes about, is in that recovery room about 24 hours after mom has given birth. If presumed father is not presumed, if alleged father is there, then social worker will say, explain what this all means. They'll tell you about it. Then he and mom would sign the affidavit there together. If mom or alleged father or anybody else discloses to the social worker that mom is married or was married at the time of conception, then that social worker is not supposed to allow people to sign an affidavit of parentage, because there's that presumption. So that's how that process is supposed to work. Whether it actually works that way in every scenario, I gotta believe that's not true, but that's the idea. Yet, parties can sign an affidavit of parentage later on. Most of the time, it happens, at that, because they don't even know it exists. They don't even think of it, right? You only know it exists if you're at the hospital and this hospital staff comes in and does the inquiry. The AOP includes a couple of different things, that one of which I really want to highlight here. Number one is the acknowledgement that this is a legal document. This is a sworn statement. You're taking an oath before you sign off on this thing, and that this is a document that is going to set in motion a lot of things. That it's voluntary. You don't have to sign this if you don't want to sign it. If you don't feel like you have all of the facts and the information to proceed with signing this, you don't have to sign it. If you sign it, it says in there, and it says in there in quite fine print, because there's a lot of info on this thing, that by signing this affidavit, the mother is awarded initial custody of the child with no prejudice to the alleged father. What that means is that the mother has sole legal and physical custody. The father has no rights to parenting time. The father is not obligated to pay support. But the father is not prejudiced. He has standing to bring an action later on to seek custody and parenting time and potentially child support. But, and this is still like outdated, the legislature has not gone on board with the fact that not as many people are getting married as they used to. And yet there's still very much this, by virtue of being married, you get paternity built in. It's a package deal, right? But if you're not married, then, and you want to establish paternity, you sign this form and you're the father, you are giving the mother sole custody, because there's no marital bond that ties mom and dad together. And that's the way the law was written. That's the way the law is still today. It doesn't mean that you're barred from seeking, court action. But if a dad wants to have enforceable rights, the affidavit of parentage doesn't do that. It just lays the foundation to say, you don't have to go to court to establish paternity. Mom and dad have agreed to establish paternity. But if you want to have court-ordered and court-enforced rights to this child, then dad, you need to go to court and file a complaint for custody, right? And as part of this deal as well, when you sign this form, you're waiving your right at that time to undergo any genetic testing, right? If you want to do it on your own after the fact, if you want to do it on your own before you sign, you can. But when you sign it, both parties are acknowledging that we've not done any formal DNA testing to determine whether or not this father is in fact the biological father of this child. What happens then, once you sign that affidavit of parentage, it gets sent to the Department of Vital Records in Lansing. They're responsible for tracking all births, deaths, marriages, and divorces, and they'll produce the birth certificate. And just as a side note, a birth certificate or a birth record is not a legal document. I mean, agencies and various schools and things like that will ask for the birth certificate, right? But it's not the legal document. In fact, it's more the memorial document that is produced from the affidavit of parentage. The affidavit of parentage is, in fact, a legal document. It's not a court order. But if you get into a situation, let's just say, where you've signed an affidavit of parentage, mom isn't letting you see your kid, and you go and try to get your kid, law enforcement is certainly going to ask, okay, so do you have a court order? Were you married? You say no to those things, then they will likely tell you your affidavit of parentage, dad, that you signed actually gave custody to mom. So this is a very common document. If you want to file to establish paternity, then you need to get a copy of this. You'll need to get a copy of the affidavit of parentage if one was signed, because the court needs that piece of evidence to proceed forward. So the law around revoking paternity, it's a higher burden of proof, like I said earlier. So the burden of proof is on the plaintiff or the moving party to show that the acknowledged or the presumed father is not the biological father, and you got to do that by clear and convincing evidence, which is very obvious, clear evidence. One court called it evidence that would shock the conscience of the court. One appellate court called it that. It's kind of like beyond a reasonable doubt in criminal court. It's much higher than preponderance of the evidence, which is what we need for establishing paternity. And the reason why is that we already have somebody, right? We already have somebody named. So what we're doing is we're asking the court to undo in some fashion, a legal obligation or a legal, paternity that's already been established. So it's a higher burden of proof. And the elements that you have to show depend on the manner of the paternity and how it was established, as well as what kind of moving party you are. And that's, again, to get the DNA testing. So if you're revoking an affidavit of parentage, parties aren't married, there isn't a court order, somebody just went and signed an affidavit of parentage, then it is in fact the same standard that we talked about, or the same types of evidence that we talked about in getting an extension of that filing deadline. When we talked about the timing of filing when there's an affidavit of parentage, you got to show that there was some mistake of fact, some newly discovered evidence that could not have been found before the affidavit was signed. There's some fraud or misrepresentation or misconduct, or there was some duress that either mom or dad was under in signing the affidavit of parentage. If the paternity was established through a court order, then the only way to do this is if the affiliated father, and that's the father who's been named in the court order to be the father, failed to participate in the filiation proceedings, meaning there was a default judgment entered against him because he didn't engage. Remember earlier on, we talk about you get something from the court, even if you're in prison, even if you're in jail, don't do nothing, do something. But in this situation, if dad didn't do anything and the court established paternity, that would be the basis that he could plead, is that, you didn't decide the case on the merits, you decided it on a technicality. Or the other option is by agreement of the parties. Everybody agrees that we want to change this thing. It's very hard to do when there's a court order. The third option, or the third avenue, is when there's the marriage. And it depends on whether the mother's asking to do it, whether the presumed father's asking to do it, or the alleged father. And you can see in the slide here, we're talking about essentially evaluating the interest between the acknowledged or the presumed father and the child. So if that person hasn't supported this child for 2 or more years, or that person has never really lived with this child, and the child is still under the age of 3, in other words, they're not holding themselves out to be a father, then there's a basis there. If the presumed father actually, that would be the husband in a divorce case, right? So that person actually has the easiest avenue to get out. And again, to get the DNA testing is what we're talking about. To get that DNA testing ordered, is that He can do it for any reason whatsoever before the child turns 3, or raise it at any time when he files for divorce, or mom has filed for divorce. He can bring it in that case. And again, satisfying any of these elements then gets you the goal of ordering the DNA testing that's going to tell us, whether or not any of these people involved in this are actually the biological father of this child. So what happens after court? If paternity is established, then the standards for establishing and modifying custody, parenting time, and child support apply, like we talked about a couple of months ago and last month with child support. So once you get paternity in Michigan, boom, 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 you get custody, parenting time, and child support. Now, it's not necessarily an automatic, but the court's going to make decisions on that, right? So we're going to hear evidence. These paternity cases that are successful are some of the longest, because you got to go through that extra hurdle of getting a DNA test ordered, and then you have the custody battle side of things. Now, granted, right, I mean, people can reach an agreement at any time along this journey on any one of these issues. But, once paternity is established, then you proceed to custody, parenting time, and child support. The court is supposed to, once you've done that established, gotten that order of filiation, the court is supposed to send the paperwork in to the Department of Vital Records to either amend the birth record and add a father. Sometimes the birth record only has the mother's name, so we're adding a father in that situation, or produce a new birth certificate if one was never actually done. If paternity is revoked, then the action is concluded. The court will and is supposed to, again, send that paperwork in to produce a new birth record, remove the father who's named on there, and add the correct father on there after proved by DNA testing. And then finally, if there's a valid court order out there for custody, parenting time, and child support, and a father's later determined not to be the biological father of this child, the child support is done. You don't get it back. So even in the evidence of fraud and things like that, the idea is that if you don't agree with the order and you don't think that it's fair, you don't think paternity is actually appropriate here, you got to act right away. Don't wait. And that's kind of the theme with when you got to file the motion to revoke paternity, is you got to do it sooner rather than later, because by not doing something right away, you've essentially consented to the status quo. The same goes for child support. So once child support has been paid out to the mother, even if paternity is revoked later on, you can't get that child support back. I feel like there was a slide in here that I wanted to cover, or maybe I missed it. One thing I want to talk about, and I think it was on a slide and I forgot to mention, is so if in any case where somebody's filed to revoke paternity, the Department of Health and Human Services, as represented by the county prosecuting attorney, has to be present. Okay. And the idea is similar to what we talked about earlier with the Medicaid stuff, is that there's a strong policy interest that the state has in ensuring there are two viable parents connected with every child, minor child. Because if something happens to the one parent, maybe even the custodial parent, they want to be able to have a second parent to fall back on. So in any case where you're filing a ROPA action, the prosecuting attorney's office has to be given notice to be brought in the event the court does revoke paternity and now potentially leaves this child with only one legal parent. That's not a scenario that the state wants to see happen. And ideally, in most cases, it's not what's best for a kid anyways. You want kids to have both parents. Now, it's certainly in situations where there's neglect and abuse, there's another avenue to take to terminate that parent's rights. And we're not talking about that. What we're talking about is that the state has to be given notice if there's going to be an effort to revoke a an established paternity order or an established paternal relationship so that it can make sure, or at least attempt to find the real father, the biological father. And in a lot of cases, that person is already there and part of that proceeding, but not always. But they want to make sure if one is going to be removed, a father is going to be removed, they want to add a father in, right? And not only just in case they get their piece, whether or not there's Medicaid involved. It's even in the possibility, right? So even if parties don't have any state assistance, the state of Michigan still has to be brought in because even though they're not on state assistance, then if only one parent, the mother in this case, remains as a legal parent of this child, and something happens to that mother, they're killed or they become disabled or something like that. Now this child or its guardian or whoever is now applying for state assistance while there's another potential father out there. That's the scenario that the state has an interest in trying to avoid. And so the state of Michigan has to be brought in, the prosecuting attorney has to be brought in every single ROPA case that's filed. So the things we didn't cover tonight, we didn't talk about custody, parenting time, and child support because we did already. So all this stuff is available on demand if you want to watch those sessions from the last couple of months. Check them out. We also didn't talk about the equitable parent doctrine, which is kind of a rare thing, but it's a deal. Is that, in some cases, and this falls under this category of equitable. What that means is that even though there's not a biological relationship, there is a parental relationship, right? And that the law recognizes that even though there may not be a biological connection, there's an emotional connection, right? There may even be a financial connection that this father has been providing for this child. And so sometimes those interests override the biological or the blood relationship right. And that's why we talk about at some point in time, in this child's age, we're not going to do this anymore. Like, it's done. You missed your opportunity. This child needs stability. That doctrine of equitable parent means in a situation where a party's married and the presumed father by virtue of marriage doesn't want out. He says, okay, I don't want, even though I know or I've learned or I believe this child is not my biological child, I've raised them as my child for years. I don't want to lose them. There's a doctrine available that says that interest for the child's benefit overrides the other parent, the biological parent's interest in intervening and taking the equitable parent's rights. So it's a very complex area of the law. It doesn't happen a lot. So it's kind of unique. So we're not going to talk about it. We didn't talk about it tonight. We also didn't talk about in vitro fertilization or surrogacy. What do we do when there's, embryos, that have been sperm that have been donated, right? I mean, a lot of this is contract law based, but it's tricky, it's thorny. We didn't talk about those situations. We also didn't talk about appeals because appeals are a whole different beast. We're talking about trial court, Marion County Court, the judges here. This is how establishing and revoking paternity works. So that being said, usually James is on this, giving me any other questions. I don't know if anybody's watching tonight because it's basketball. And I'll be honest with you.
I know you probably. I saw you sneaking glances here and there. No, but
I got my boss button up. But anyhow, so we got one more. I'll shut up, and then you can tell me, James, if there's anything. So next month we're going to wrap this beast up with guardianships. We're going to talk about guardianships, the role they play in when there isn't a custodial parent around. How do you get guardianship for a child? And we're really going to be focusing on the child side of it. There are guardianships for adults, but I want to be focusing on minor guardianship. So that'll be next month's session. So any questions out there, James?
We didn't receive any on this end. So it looks
because
like
we're all watching basketball. Nobody's even watching this thing tonight.
Basketball,
man. Yeah, I'll go back and see it.
Yep. They're gonna catch it. They be like,
we should have maybe put in some paternity commercials.
That's all good. It's out there for a later time. when March
Yep.
Madness is done. You can come back and watch it.
Oh yeah. Well,
All right. Well,
thanks again, Blair, for another good session. Again, we welcome in Isaiah
Yeah, pleasure to meet
to
you,
the
man.
team. And good night, everybody. We'll get back to basketball.
All right.
ciao.